And we are
All right.
live.
All right. Awesome. Hi, this is Curt Barone.
And this is Brad Pinsky,
All right. And we are here for a special edition, I guess you'd say, or another edition of
inaugural
Fire.
edition.
It is inauguration day, and we're not sure that we're going to be having very many people watching live, but and it's also Martin Luther King Day. This is the
Oh, right.
celebration.
Of course.
It's a holiday as
Yes.
well. So, but
Yep.
I am
Okay.
in.
I am.
By the way, let me just a caveat. I am at a hotel in College Station, Texas. We're literally on the campus at Texas A&M. And the reason I'm saying that is there's a railroad line right outside the hotel. And all day and all night long, the whistles are going off. The train whistles are going off to the point where they actually give you, when you check in, they give you earplugs.
Wow.
And they say, well, it's part of the tradition here. And I'm like, well, this is where the visiting team that's playing Texas A&M should stay, because it's literally right on the railroad.
that's
And
that is
all
great.
night long. I was actually thinking, Brad, I was thinking that if I was a firefighter here, I would find out where the engineers lived and I'd give it back to them when we go
Yeah,
by their house
exactly.
in the middle of the day.
Well,
At any
with
rate,
with that introduction, the first suit we're going to cover is a whistleblower suit.
oh, there we go.
So,
There we go.
no pun intended. Um, and this is against the LAFD. This is made by a female, a former very high-ranking woman who holds the highest not highest civilian job.
Mhm.
This is not unlike many claims we've seen before, right? So she and I can kind of sum this down. She makes some concerns and complaints on numerous decisions. I'll go through what they are because it's important, to the chiefs, multiple chiefs. And she said, here's what she said. One of the chiefs' ongoing failure to repay the city for a significant overpayment she'd received. The chief had received an error, that promotions were not being based on merit and they were made in breach of civil service rules. That one's important because it's a law. Due process violations and use of details as de facto punitive action. Details, not details, specific details, but details, work details. Failure to enforce rules and regulations in an impartial manner. Bad faith engagement in the interactive process for employees who had requested reasonable accommodation. As we covered last week or so, that's a requirement under the ADA to have a reasonable accommodation meeting. Badgering and neglect of civilian personnel, and violations of city contracting procedures and rules. So here's my comment. Whistleblowing is not just saying anything you want, reporting anything. Hey, the shelves are dirty or the station is unclean. That's not whistleblowing. And I don't know what California's whistleblowing statute requires, but typically whistleblowing requires alleging a violation of law or a violation of kind of a breach of duty, or an ethical violation. And she, of her 8 things she alleges, most of these don't amount to what would withstand a whistleblowing, or constitute whistleblowing. Maybe breach of civil service rules,
Well, I,
right?
I think if you look at her position, she is the one responsible. She is an attorney. Her background, she's brought in as an assistant attorney to handle the day-to-day legal things, and then they LA has been having such a problem with employment litigation, not so much incident related litigation, but it goes back to the Tenny Pierce case. That was the African American firefighter who was fed dog food as a prank. And it turns out he was actually doing a lot of the pranking, and there was a settlement, but then the settlement got revoked, and there's a big mess there. There's actually a headline that I use in some of my classes, and it said lawsuit sweepstakes at LAFD. And it was literally analyzing the multi-million-dollar settlements and verdicts and different things that happen, all employment related, back in the early 2000s to the mid, early teens and so on in the 2000s. And so she was brought in and then moved through the organization to help deal with a lot of that and try to get some systemic change in there. And at least according to the complaint, she was highly regarded by the prior 4 chiefs, and she started having a problem now with the new chief.
Yeah, and look, you know, I think when you complain about things that are part of your job, right?
Right.
You know, it's a tough hill to climb to say you're terminated for doing your job effectively and that violates a law. But again, I don't know how California's law reads. Once you say, hey, for example, the first one, right? The ongoing failure of the chief to repay for a significant overpayment. I
Yeah.
don't know whether I have mixed feelings. You know, I've pled whistleblower claims before. They're not easy to say I told somebody something wrong was happening.
Right. There's two types to me when I lecture on this. There's two types of whistleblower. Okay. There's one type of whistleblower that is embedded in the statute. For example, the FLSA has a whistleblower, not a whistleblower, but a complaint anti-retaliation provision within that law. You can't use that retaliation or the sort of anti-retaliation provision in the FLSA if you've got an FMLA claim or if you're complaining about OSHA. So it would be statute specific. Then you have some states, and I know my state has it, has a broad whistleblower act that prohibits any act of whistleblowing. And then you've got to look at the specifics of, who do you have to report it to, what type of violation. But the violation of a law would potentially fit under many whistleblower statutes. So it really depends if you've got a specific whistleblower law that's specific for a certain act, or you have sort of a generic whistleblower type protection. Okay. But to me, this is going to come down to the proof. And, we've had a couple of cases where there was a case out of Maryland. And I actually got a chance to talk to the attorney involved in this, but she had joined a local volunteer fire department. This attorney specialized in sexual harassment and sexual discrimination law. And the guys started harassing her. And it's like, to me, that's like going into a bar and picking a fight with a black belt. Like, why would you
Right.
do that?
Right.
And I kind of come back here. You've got an attorney whose job it is to protect really prevent employment related types of claims. And now you're going to fire her. Well, what do you think is going to happen? You went,
Right.
it's like going to a bar and picking a
Right.
fight with somebody you know is a black belt.
Yep.
Now, that's not to say somebody who's got a black belt can do whatever they want, because at some point they, but I don't know.
Yeah. And look,
I'm
we're
shaking my
going
head.
to, and I think maybe what I'm going to do next is we're going to jump to another whistleblower case because I want to juxtapose these two a little bit. So let's do that. But by the way, I should have said this at the beginning. One of the cases we're going to, not a case, one of the scenarios, because it's not yet a claim or a lawsuit, we're going to do at the end. It is an extremely interesting issue. Everybody should, I hate these websites that say wait till the end, wait for it, but you should wait for this, because what we're going to talk about, the tease, is whether going into a car accident victim's glove compartment could be a Fourth Amendment violation. And we do it all the time. I've done it thousands of times, right? So we'll get to that. You and I may disagree. We may agree. Who knows?
I think we're going to agree. We've done it thousands of times, but it doesn't make it right. But we'll get
right.
to it.
But nonetheless, let's jump to, just keeping a logical order, but going out of order. Let's go to New Mexico, where we have a firefighter who's alleged gender discrimination and whistleblower retaliation. And this is, again, another lawsuit. And we got a third one we're going to cover, also is kind of similar today. But here we have a New Mexico firefighter was terminated last year, filed suit, saying gender discrimination. And there's always a retaliation component, I'm sure, but also whistleblower retaliation, which is a little more specific here. The claim alleges that he was treated differently. He was singled out for being rude and too direct with colleagues in public, and was retaliated against for speaking out against proposed changes to the department EMS response protocols. Now that summarizes it, and I want to focus on that last one, right? So, because when I read this, I'm curious how you think, but one of the complaints made is that this employee was vocal against the department's policies and choices, and then was retaliated against for being vocal. That is a very different whistleblower allegation, and I think fails as a matter of law in my mind, because on the one hand, right, in LA, we're allegedly complaining about ethical wrongdoing, maybe violations of the ADA or civil service laws, right? Here we've got, I complained about something. Wait a minute. You complained because you didn't like a policy and people retaliated against you. To me, and she makes that claim, but
It's a she. It's a she.
But to me, the discrimination fails because in the McDonnell-Douglas test, she just came up with their reason, which had nothing to do with sex, gender, anything. It had to do with, I'm not saying this to her, of course, but it has to do with, we don't like what you said about one of our policies, and we're coming after you because you spoke out against it. You could have been a male who spoke out against it. We would have treated you the same way. I think that provides an independent, unrelated justification for their actions. But the complaint, when it provides that independent justification, right, to me is kind of dooming itself. I'm not saying this will get dismissed, but who knows immediately anyway. But these two are very different claims.
Yeah. No, for sure.
So we could get a little more into it. It's very long, but it really just echoes how vocal this person was against methods and things. And then they retaliated against her, maybe, right? And look, she makes out a claim saying, okay, well, I wanted to go to paramedic school and you picked two lesser qualified males. Yeah, without more, that would have been fine. But then she adds in, but you were mad because I was picking on your policies, et cetera, so you retaliated against me. It doesn't work to me.
Yeah, that allegation, there's a couple of allegations here that concern me, but that allegation, I've seen that before. I've seen you have a female who's senior that wants to go to a certain training program, and lesser senior males are sent. What they omit, and the complaint is one side of the case, and you don't know the other side, but the case that I'm familiar with, you have a female that's assigned to a ladder company, and she wants to go to a class for hazardous materials, and there are people that are assigned to a unit that does hazardous materials that are junior, but they need to go because
right.
for that reason, Yep.
So
there are explanations for why someone might be treated differently. You don't get that just from the complaint. You've got to look at the answer and then see how the case law comes out. One of the things that she does allege that I think is a fairly common thing is that she was being criticized for being too direct and abrupt.
Which maybe a male would not have been criticized.
Would not have been. And that's a theme that you see in a lot of lawsuits. It may also have some validity in some of the literature. There's there's some research out there that supports that. However, here's the problem. It doesn't mean, it's just like any other type of research that looks at statistics. It doesn't mean that in a given case, your version of being abrupt was appropriate.
Correct.
So just because the data suggests that it's more likely that a male would be given a free pass on and a female wouldn't, it doesn't mean in your particular case that it would have, that's how it would have been. So difficult facts to have to prove in court, but we'll see.
It is. But I really like how this week those two whistleblower suits kind of come up against each other because they're very different in retaliation. But anyway, okay, so let's keep moving on. We have this is my client. We have a former New York fire chief. The chief is not my client. The fire department is. So I know this in depth, but I'll stick to the headlines a little bit. But I have a bigger point. So we have a former New York fire chief is facing felony charges because he basically photoshopped or doctored an FAA, a federal drone pilot's certificate. The drone was complained about, right? So it came up that there was a complaint about the drone. By the way, the FAA can track every registered drone, as can most of you. It's on a public site. You can watch drones flying around. You can see, and you can know who they're registered to. There's no privacy here. And when asked about, do you have a drone license, he produced this. That is a bad idea. But here's the scary part. In the last 3 weeks, I have two other fire chiefs. I've got one fire chief who has been arrested now. The headlines haven't hit, but certainly they'll be here for doctoring their firefighter 1 and their fire officer 1 course. They were never in the course, and they doctored the course or doctored the certificate. Look, it's easy to do, right? Scan it, change your name, whatever. Pull one out of somebody's files. Do not be doing these things. Those are multiple state and, in this case, federal felonies. Bad idea.
Yeah, almighty.
Yes.
Yeah, I think when I first read it, I don't know. One of the things that crossed my mind was that he had the certificate, but he couldn't find it. So he doctored something to make it look like. I think that's one thing. But this is, documenting that you're licensed to operate a drone, given all of the issues that we're seeing here out in California with the drones interfering with air operations and everything, just incredible. But I'm surprised.
And I tell you,
there wasn't any federal charges here as well. Maybe that might be coming. I don't know.
I suspect it will come, but here's what I know. When the federal government, when you violate federal law, the state, just as a practical matter, and the district attorneys are less likely to just say, yeah, we'll just accept a small fine or penalty. I mean, you violated federal law. This is not a good thing. And people think, oh, I just change a few words on a piece of paper. That's not the act, right? That's what it took to commit the act, but that's not the act. This is fraud. So don't be changing, forging documents. And I said I have a third one. I have a third one, almost the exact same thing, falsifying Firefighter 1 documents. I don't know. It kills me. Okay, let's see. So before, again, we haven't done 5 yet. Let's see. We did LAFD. We'll hold on the Fourth Amendment. Virginia. Okay. Second to last one. Virginia. This is the right holding, I think. But as we get here,
not the one we want. It's not right in terms of the law. It's wrong in terms of what we as firefighters want to see. But
correct. So here, a firefighter had succumbed to cancer, and the Virginia's presumptive law says you have to have a lung cancer or something to your lungs. And in short, they couldn't even get their own doctor to say this was, lung related, et cetera. It might've been cancer. And look, even if the cancer was caused by firefighting, but they couldn't come up with the amount of evidence needed, the small level. It really was not a huge burden, just a letter from the doctor.
I think this came down to a poor doctor's report. I really do, because he had cancer. There's no question that he had cancer.
Right.
But the way the doctor wrote it up, it raised enough questions that, and I'm not sure who was really making the argument, whether it was the city or the workers' comp board, whomever was making the argument, but they would not look past the fact that the doctor's report did not say he died of cancer. It said he died of respiratory failure. Well, you can have,
he died as
right. You can have cancer and get shot. You can have cancer and die in a vehicle accident. The cause of death is what needs to be really at the center issue of that report. And it said respiratory failure. It could have said respiratory failure secondary to cancer, but it didn't say that. And you would think, I mean, maybe the doctor felt he was stretching and didn't want to go any further than that, but you would have thought the attorney would have went back and say, hey, doc, this is what we need. Can you?
If true.
Yeah, if true. And I don't think there's anybody out there listening that wants the doctor to falsify something, but at the same time, it didn't have the language that the court, the workers' comp board and the court needed. There's an old saying. What was the saying? I'd rather have one good witness than all the law on my side.
Yeah.
But you got to have that. Here, if that doctor had worded the report a little bit differently, I think we'd be looking at a different outcome.
Right. And look, Virginia's law is not a great law. It's a little bit good, but it's not great. New York has a much broader law that's many cancers, not all cancers and sarcomas, but Virginia's law, it has to be a respiratory disease, which I think is really old science, right? I mean, that kind of comes from, the only thing we get affects our breathing.
It does list some other cancers and so on, but the bottom line is the wasn't the death certificate, but the report that I guess the pronouncing doctor made was that his death was due to respiratory failure and not due to cancer.
Yeah, and it's got to, you got to meet the statute. It's an unfair. It's a fair holding. Maybe it's not a great statute. Maybe it's just unfair. But the law isn't going to say we're going to protect the firefighters from anything that happens, from getting hit by a bus, right? It's got to be. They make choices. What can people afford? What relates to
one of our topics, one of our favorite topics is causation. And when you can't connect the dots, yes, he had cancer, but he didn't die from it. If you can't make that connection, they're not going to give you the benefit of the presumption. If you can establish that the cause of death was related to cancer, not just that he had cancer, but that cancer caused the death, then we will presume that the cancer was job related. Right. But you're still one step removed from that.
Yeah. So it's unfortunate, but not unfair. Okay. Now let's go to Bridgeport, Connecticut. This is,
alrighty.
And look, I mean, if this turns into a lawsuit, this will be #1 on your and my end of year, and you can't make this stuff up and ever.
And
but
Brad, I hesitated to even discuss this, and you and I talked about it. We weren't sure because we didn't want to give the potential plaintiff in a case here, any of our inside knowledge. But at the same time, this is something that it's more important, I think, that folks be aware of it. Yep. And take the appropriate steps to prevent this from becoming an issue than it is trying to protect one department in one scenario.
And look, so the facts are pretty common. Allegedly, now this is a member of the Democratic Town Committee, I guess, in which the fire department is located. I think he was involved in an accident around 4 a.m., which when we see accidents at 4 a.m., we have some thoughts what they might.
Well, let's give them the benefit of the doubt. Let's give them the benefit.
Right, just happened. In any event, the driver was passed out and slumped over when first responders arrived on the scene. And when the lieutenant went to assist, the driver allegedly punched the lieutenant in the face, and the lieutenant was reaching into the glove compartment, apparently to get registration or something, and closed the glove compartment on his hand. So he's possibly going to complain that we have a Fourth Amendment violation. I want to jump in with a really quick thought. So when we go into a house, and you lectured at my conference on this a while ago, a couple of years ago, when we go into a house as firefighters, we can open doors to look around the house if it relates to the investigation we're doing. So we go there for a smell of smoke, right? And we open the doors. We are a licensee, we're invited, or an invitee. We're invited into the house by the smoke or the alarm or whatever. We have the right to go in, therefore, we have the right to enter it, but our ability to walk around and open doors is limited to the reasonableness of how it relates to what we're investigating. So again, opening a basement door to see if there's smoke down there, right? Where's the alarm coming from? Okay. Now that's pretty well settled law, I would think. So now we go into the glove compartment. I start with this. If we don't know who this individual is and he's unconscious, then going into the glove compartment to get a name, right, on your registration is 100% related to the investigation, related to the call. So if right now, the problem I have is, because I like you, if we could, to address this exact situation, what about when the call's not over, we've loaded the person, we've extricated him, he's loaded, and then the police are like, hey, do you know if there's a registration in the glove box, which also happens, and we go in and get it for them. I'd like if we could talk about both those scenarios.
Sure. Well, is there some, first issue is there some sort of implied consent? And to your point, is there an exigent circumstance? So we got to kind of tease that out. If there's an exigent circumstance where we need to get that information, that is typically what justifies us going in someone's house, even if they are at the door trying to keep us out. You know, there's a fire in the house, a potential fire in the house. If it's legitimate, we're not just randomly going to somebody's house and trying to break in, where we've got a legitimate reason for suspecting there's a fire there. So is there an exigent circumstance? Put that to the side. The other thing is there implied consent when we're, for example, we're treating someone, we're in the vehicle, maybe where one firefighter's got, you know, cervical stabilization, neck stabilization, and someone else comes over and reaches it. We're already in the vehicle. Is their expectation of privacy diminished somehow by someone opening the glove box and taking that out? If the person is there and the person is looking at us doing it and they don't complain, is there implied consent? There's a lot of different parts to the whole implied consent part. What we have here, though, is a different situation, and let's assume that the man is not passed out and slumped over. Okay, he's conscious and alert and says, "I don't need your help. Don't go in my glove box." That presents a different scenario. Okay, right. Now let's talk about this scenario where he was passed out. He is slumped over. It's 4 o'clock in the morning. And maybe we do know, maybe we don't know. Apparently this gentleman was fairly well known in town and was an activist in many respects. But at any rate now, he's passed out, he's slumped over. We go in there to help identify him, like you suggest, okay? Well, I think there may be implied consent for doing that. That we're not looking for drugs. We're not looking for anything that is evidence of a criminal or some sort of misconduct nature, where they're trying to get information that's appropriate for the circumstances. Now you have the guy passed out and slumped over, but all of a sudden now, maybe he was, when we initially got there, passed out and slumped over. Now all of a sudden he's angry and hostile. We still have a question about whether or not he's competent. Is he just overtired? Is he impaired somehow? Does he have the capacity? Because if he lacks the capacity, now we go back to implied consent. If he has the capacity, then there's a fair question about whether or not we should have honored his instruction not to go in the glove box. Right. So there's a lot of different factual parts to this that, to me, it's a classic close play at second base, where you can't say everybody who's trying to steal second that has an even number is going to be out, and everybody with an odd number is going to be safe. There's a lot of nuance in there. You've got to look at all of the facts that are going into that close play.
And to me, one of the biggest questions is this: what were you looking for and what were you going to do with it? So, for example, let's assume they said, we're looking for the registration. Okay, what were you going to do with it? I was going to give it to the police. Well, wait a minute. Then you're acting as an arm of the police. It's not for your reports or helping the patient, identifying them, whatever, right? You're acting as an arm of the police. And then the whole question is, can the police ask or themselves, right? Can they go into the glove box under these exigent circumstances? I believe they can. They can. Right? I mean, because the car could be driven away, or they got to call in the car, maybe a warrant search, all of these things they have the right to do if they can't get something from the driver. But if you were going to use it for your benefit, meaning I, as a firefighter, need it, A, for my report, B, I want to notify next of kin, C, I want to see if it's his car so we don't identify the wrong person and all start we get a report, oh, this person's diabetic. Oh, wait, that's not who it is. I mean, there's a lot of reasons to do that, right? Mm-hmm. And you just got to have a general valid reason. And I say you can go into the glove box. Now, just because you go in, what are you going to find? Okay, I go in, I found a gun. Whoa, right? I was looking for this, I found a gun. Well, if you're going to charge them with hiding illegal possession of a handgun, well, maybe it comes up then, maybe it doesn't. But what's his damages?
Yeah, and there's nothing wrong with that. We go in there, let's say we go in there for a bad reason, for an illegitimate reason,
right?
Find a gun. At the guy's criminal trial, that may be suppressed. Okay, there's your solution. Right. Okay, that's the solution, is it gets suppressed.
But what's the harm? What's the harm? I got your registration. I got, right? I mean, what's your...
I think at the end of the day, that's what's his damages. I mean, he could literally go to federal court, win, and the jury, based on the facts, could say, we're going to give you 1 cent.
Yeah, yeah, exactly.
Literally, they could do it, or 99 cents if they're in a generous mood. You've got no damages.
Right.
What
Right.
are you what's the harm?
And especially if the only thing you found in there was car registration, well, that's public knowledge anyway, which the police could get regardless. When we go to, I don't know what you do, but when I taught car fires and how to fight a car fire, one of the things I said is, okay, as soon as you can, check the car, check the trunk. Let's make sure nobody's in there. And I had someone complain, why'd you go into my trunk for a car fire? Because I didn't know what was in there. If anyone was in there, we checked the trunk, period. And that's just what we do. And so people have claimed, well, you can't go into my trunk. Well, yeah, I can. Your car's on fire. I'm going to check every part of that. And they were pissed when we found something. It wasn't anything big deal, but they were pissed. We went into their trunk. I think they were living out of their car or something, and their suitcase was in there. We pulled all their shit out and threw it on the street to make sure we could save the car. And they were pissed. They kept saying you had no right to go into our trunk, but we did. Right? We did. Your car's on fire. We need to look everywhere. So I guess what I'm saying is there's got to be a valid reason.
Yeah, and assuming that this vehicle is going to be towed, there was apparently an accident for which he ended up being charged with unreasonable speed for conditions, but it was probably going to be towed, and the police have a right to do an inventory search. So. And an inventory search is going to be looking everywhere in the car, including the trunk, including the glove box, including under the seats and any containers within the vehicle. They've got to do an inventory search. So.
Yeah, and I also wonder, and I assume it's the case, like, again, with a house, we said the fire department is viewed in the law as is called an invitee. When your alarm goes off, when there's smoke showing, we are invited into your house by that operation. And we have the right as an invitee to be at your house. It's kind of the same. It is the same thing with a car. You got into an accident, whether your fault or not. You invited us into your car such that we need.
I think it's a little different. I think that there's, I have lectured and written on this issue, and there was a case out in New York, really important issue on this. But when you're dealing with a building fire, a house fire, there's the potential for somebody's house to extend to someone else's house. And therefore, there's a societal concern that if you have somebody who's whatever is just being difficult and won't let us in the house, and we just walk away, and now that house gets fully involved and extends to the next one, that there's a public concern, but by virtue of which we have a right to go in somebody's house against their desires, right, assuming that we've got a legitimate reason for doing so to make sure that there is no fire. And this is exponentially worse in a high-rise building because you can't have somebody on the 8th floor that sets their apartment on fire. We go to the door and they say, no, sorry, you can't come in. There's other things that you have to. So it gets a little bit less when you get out to a rural area, but it's not totally extinguished. So I'm not sure that reasoning applies to a car fire. Okay. I'm not.
Well, car fire, yes, but maybe not a car accident.
Car crash, but even a car fire, I just don't think it has the same. Now, certainly if let's put that car in an underground parking garage at a mall where there's 1,000 other cars, then certainly it has the potential to affect beyond that one vehicle, and we would be able to force our way in and so on and so forth. So a lot of different things to kind of factor into this one.
Yep. And look, this is not totally different than we grab somebody's wallet off their person, right? And we look in their wallet. Now, I don't ever advocate touching anybody's wallet. The police are there. You ask them to grab it. I'm not touching anyone's wallet. We've seen enough problems with real problems, people stealing stuff.
And it may be necessary where the person's unconscious, but where the person's conscious, I would say, and I think that's really where I would go as well, where the person's conscious and they're with it, they're competent, they're not somehow impaired by whatever it may be, and they tell you, don't go in my pocket, don't go in their pocket. If you need it, same thing with the glove box. When they tell you, don't go in my glove box, and they're competent, that's not to say this guy was competent. We don't know.
Right.
Maybe he was, maybe he wasn't. Maybe he, I don't know. Maybe he got a bump on the head in the accident, and that's why he was slumped over. Maybe the reason he was slumped over is what led to the accident. At any rate, maybe he was competent, maybe he wasn't. All of those things have got to be teased out in this.
And the answer to this, if anyone knows Curt and I, you know what we're going to say. The answer to this is a policy written in advance, because there's no way you should leave this discussion, this consideration of these extremely complex constitutional issues to let's figure it out on scene. Let's have a policy that lays out some of the scenarios. And as Curt and I talk, as we come across these issues, these are things we can and will deal with in our must-have policy service. And we will address these novel issues, which you are not going to see in any other type of policies or policy service, that because we follow this stuff, right? It's not even a lawsuit and you're pulling it out ahead. Talk about ahead of the curve, right? I mean, and that's what you do. So we will and can and will give models on how to address this, but you cannot leave chiefs, you cannot leave this to your firefighters to figure it out on the scene and expect they're going to get it right. Police get a lot of Fourth Amendment training on what you can and can't do,
and that's evolving too. I know folks who write policies for law enforcement, they're constantly reviewing Supreme Court and Circuit Court cases on Fourth Amendment and adjusting their police department policies. We can't just put our feet up on the couch and expect that we have a policy that was written 15 years ago, it's still going to be valid.
In Florida, a court just held that a dog cannot give probable cause for a warrantless search in a car. It's a great case. I think it was last week. But the court came out and said dogs cannot be used for warrantless searches of vehicles. And
a trained
dog. I was shocked. Yeah, I'll get that for you. It's really very interesting, but it's this exact issue.
How can that not give you probable cause?
And it's Florida. You think of all things, Florida would say yes, but they said no to the
California,
dog.
yeah, I could see a judge in California, certain judge.
Florida,
New York, I could see a judge, but
yes,
Florida, really.
Yeah, and I think it was an appeals court too. So I will get it. We can talk about it.
Was the dog certified?
It's a trained dog.
Really?
Used by the police department, so I assume so. Yeah.
That's incredible.
Yeah, it is incredible. I was shy. I had to read it like 3 times. Like, I'm not reading this correctly. But it's the exact same issue. This is where that goes. And to the point, you cannot expect firefighters to stay on top of this. This is last week. So if you're a firefighter in Florida, right now the law is a little much more against you or against the police. But I'd be thinking, okay, what can I look at? And when it's got to be in a policy. You need a policy. Curt and I will help you draft a policy. You need a policy. And by the way, sign up for Must Have Policy Services. And you will get multiple policies a month, and we'll talk about it. Curt, that is it for today. I did not hear one train whistle, but I am told we have a new president.
I think they waited till I went to bed last night. That's what it was.
It could be. It could be.
Yeah,
so in the time we started this, we now have a new president in the United States.
Oh, really? Oh, wow.
Sworn in.
So
12 o'clock.
All right. Well, we'll see everyone again next week. Next week, I'm going to be coming to you from Columbia.
Oh,
Columbia.
Jesus.
Columbia. As in not Columbia, South Carolina.
Columbia, home of cocaine.
Bogota, Columbia. Yes, Bogota, Columbia. So we'll see how the internet connection is, but looking forward to the trip. I'm going from here, flying down there, and then we'll be back the week after. So
the life of Curt Ferone.
Oh my God. All right. Well, that's going to do it for another edition of Fire Law Roundup. We'll see everyone again next week. Thanks, Brad.